of misinformation being given out when I look on the internet, when I hear people talking. And for those of you who don't know who I am, I'll come to that in a moment, because this isn't about me. This is about you, and this is about your business. It's about your properties, and it's about you staying the right side of the law. So, just let's just run through a couple of things. The reason I am here is very, very, very clear. The reason is I have done a lot of things right. Yeah, I have done a lot of things right in property. I have been helping in property for a very, very long time. I've built my own portfolios in buy-to-lets, in flats, in houses, in HMOs. I've built HMOs. I've helped people train in HMOs, in strategies and how to do things correctly. But one of the things I can tell you is that I have also done a lot of things wrong. I've done them wrongly, should I say. I have done a lot of things wrongly because I sometimes had to learn, and I'm going to talk about phrases today where I treated them as not important. But the most important thing is to understand how to do this the hard way or to do it the easy way. And I'm going to share with you how to do it the easy way. Okay, but let's start with the hard way. The hard way, first of all, is to apply for licenses incorrectly. Now, that may seem crazy, and lots of you might think, yeah, I can do my own license, but people do get them wrong, and there are consequences, and I'll come on to those consequences called civil penalties a little bit later. But we had a lady in Norwich came to the firm that I work at, and she said, I've got a civil penalty, and I'm using an agency, and the agency were going to do the license, but I did it myself. And what she did was she decided that she would declare that her house was compliant, but when the council came to inspect for the HMO license, it wasn't compliant. So she got the civil penalty for that false declaration. The other thing that's very important is people misunderstand the requirements. And because they misunderstand the requirements, they put down and write things incorrectly and create mayhem for themselves. And the other thing is, many of you will do things to your property and overspend and over-declare what you're doing when you didn't need to do it. Now, I don't want to live in a house to the minimum standards, but some of you are doing things you shouldn't do, and you just need to check what the local amenity standards are. So you might be putting in kitchenettes in rooms, you might be providing extra facilities, which actually are making things more difficult for you. So, but there is an easy way to compliance, and the most important thing is that you go about it in the easy way. So let's get a couple of things clear, and one of those things is that there are only 3 types of property license that exist today. Only 3. Now, let me just check with you. Has everybody here got a pen and a piece of paper with them? Can you put in the question box yes or the letter Y if you've got a pen and a piece of paper with you? I worked for a man many years ago, and he said, the worst ink will last out to the greatest memory. Yeah. And the reason I ask you to, if you've got a pen, is we're going to be doing some quizzes later. We're doing some polls, and we're going to be finding out some things about what you do and you don't know about licensing already. So that's quite important. So now few more people joining us. So thank you. Welcome for those of you who are joining us. You have missed a few minutes, and I'm just talking about there are only 3 types of property license. Now, let me be very clear. A mandatory HMO license I will define in a little while, but a mandatory license is one where there is a property of shared occupation of unrelated people, and you must have that license when there are 5 occupants from 2 households. Now, people get really, really confused. So if you've got your hand, put your hands out in front of you, and in your left hand, close down your fingers so you've got 2 fingers. And on your right hand, open your hand out so you've got your 4 fingers and your thumb out. That means mandatory licensing. Look at your left hand where you've got the 2 fingers. That's 2 households. Households very clearly are people who are unrelated. Now, for the purposes of making it simple, they are not connected by blood, and they're not connected by sexual union. That makes it very, very simple. The only exception to not related by blood, which would make you part of the household, is if you are paid living domestic staff, such as chauffeurs and housekeepers. They would be part of the household. That's the only exception. Now, looking at your hands, where you've got 2 fingers on the left and 4 fingers and a thumb on the right, what I'd like you to do is take one of those, take your thumb and your finger, so now you've got 3 on the right and 2 on the left. Most councils today are bringing in additional licensing when the property becomes an HMO. And an HMO is formed when you've got 2 households, and that 2 households again is people related by blood or by sexual union. And on the other side, there are 3 unrelated occupants. That is when a property becomes a house in multiple occupation at 3. 2 and 3 becomes an HMO. Don't let anyone else tell you it's any different, because it is. It's only at 2 and 3 it becomes an HMO, and HMO management regulations kick in at that stage. So with your pen, write down this: the management of houses in multiple occupation regulations 2006. The management of houses in multiple occupation regulations 2006. They kick in for additional and mandatory licensing. So additional licensing means it's a license you need to get earlier. It seems to imply, and many people have said to me, oh, that's when I've got 8 or 9 people in the house. No, it's when you've got 3 people and the council has additional licensing in place. You need to get an additional license. There are civil penalties for not doing that. So mandatory is 2 and 5. Additional is 2 and 3 people, 2 households, 3 occupants. Just let that sink in for a moment. Now, selective licensing is completely different and got nothing to do with houses in multiple occupation. This is where the council has decided that there's an area they want to improve housing, and they require the landlords to register each property for a selective license. That's for buy-to-let properties. I'll do another webinar on that on another day, but it's very, very important that we get those clear and understood. If you understand, could you put the letter U in the question box? The letter U. Excellent. All right, so I will come back to that towards the end. We're going to be doing questions and answers at the end. We're going to have a little bit of time to do that. So don't worry about if you've got questions, make a note of them and we'll come on to those shortly. Okay. So, okay. So HMO licensing, I've said that now, but the things when it comes to licensing you need to be aware of are room sizes, the amenities and the refuse in the house. Now, I said 2 households and 5 occupants. Room sizes for single occupation, 1 person in a room, the size of the room needs to be, in old money, 70 square feet, or in new money or metric, 6.51 square meters. That's 6.51 square meters. Room sizes are very, very important. The other thing that's very, very important is if you're going to have couples in your HMO, the room size needs to be 10.22 square meters. So 6.51 and 10.22. Now those are the national minimum standards. But your local council will have amenity standards, and if there is no communal space for the occupants of the house to sit and eat and to share, they will have other requirements which may raise those sizes. Now, one of the things I want to be very clear about is amenity standards by councils are their idea. So if you've got a property in, say, the London Borough of Newham and one in Birmingham, the standards and the amenities they set may be different. And some of those amenities and standards have no foundation in law. They have got no foundation in law. Some of them are complete craziness. And some of them are set because the planning under the planning department have said they need a certain size, or in a building regulations department, they've said they want something. But that doesn't necessarily apply if you're just taking a house and moving it quite clearly from a normal living house into an HMO. And that's under planning. I won't cover planning today, other than just to mention it in a slide, but I will cover most things as we go forward. Now, the other thing that you as a landlord who are doing under HMO licensing, under license conditions, they will tell you that you are responsible for refuse. So you are responsible for making sure, and it will be a license condition, that the refuse is dealt with in each and every house. This is most important. Now, licensing and management regulations, HMO additional and selective. HMO and additional HMO licensing comes under the Housing Act Part 2, the Housing Act 2004 Part 2. And Part 3 is selective licensing. So an HMO is at 3 people, unrelated, in an additional area, will need an additional license. But what you're going to find is in many areas where there's selective licensing, people put 3 people in a house that has selective licensing and don't apply to change the license for an additional HMO license. It is massively important that you do that. If you've got the wrong license, you can still be fined. Okay. The other thing that's very important, I talked about amenity standards. Councils, the local council, base their amenity standards generally on 2 pieces of information there: the Housing Health and Safety Rating System and LACORS, and that's a local authority guidance for houses. So you need to understand what those both are. HHSRS, there are 29 points to the Housing Health and Safety Rating System, which the council will enforce, and if they don't enforce, the Health and Safety Executive can. And it's under these surveys they do, they decide whether to enforce and to prosecute. So you want to keep yourself away from those problems. And the best way to do that is to have somebody who understands HHSRS, a certified practitioner, do a survey for you when you're doing a house and when you're having your house done up. The other area that's very, very important is LACORS, which covers various facilities, but how you should put smoke alarms, how you should have fire doors, and what the amenities are. That's a very long document as well, and I won't go into that here, but your environmental health officer at the council will advise you, but do remember, they're advising based on their own information and their own desires. You know, if you were convicted of a crime, you wouldn't listen to the police who are prosecuting you, telling you what to do. So do seek proper independent advice from somebody who's experienced and has done this a number of times before. That is probably not going to be your mate in the pub. It's probably not going to be a landlord who hasn't got any HMOs, and it's probably not going to be a landlord who doesn't have high standards. It's more likely to be somebody who's experienced in property, somebody who's an environmental health officer. It could be a solicitor who's experienced in property and licensing. It could be a firm of consultants or surveyors who do that, or it could be a specialist in licensing or defending landlords when they get into trouble. But your amenity standards are set by the council, and these are not, most of the time, the law, although HHSRS became enshrined in law through the Housing Act 2004 and is really formed part of Part 1. But I won't go into all the legals, you don't want all of that. And again, there's the Management of HMO Regulations 2006 that you put in, and that's very, very important that you understand all of those. Now, there are some exceptions. When a property is owned and owner-occupied with no more than 2 lodgers, then it is an exception to the rule. It is not an HMO when it's got 2 lodgers. And if you are not in the property, or you go away or leave the property for a significant amount of time, and you put more people in where to replace you, you would be creating an HMO. This is one that people do get caught out on, and you must get them on the right agreement, the right tenancy agreement, a lodger agreement, and the rights of the person is very, very different. But I would suggest if you're going to have people in your home, you do some of the fire risk assessment stuff as well. Now, it says there, a property that is occupied by two people who form two households. So if you and your friend go and get a 2-bedroom flat, the two of you live in that 2-bedroom flat in separate bedrooms, you are two households and two people, it is not an HMO. But if your mate, he or she brings their boyfriend or girlfriend or partner to come and live with you in your property, now you're 3 occupants in 2 households, because your mate's not related to you by blood or sexual union, then you've created an HMO. And if you've done that in an area where additional licensing applies, you need to get an additional license. If additional licensing doesn't apply, then you clearly need to follow the management regulations, which were in the last slide at the bottom there. Now, I'll be quite frank with you, what you need to do for one and another, depending on the type of landlord you are, will determine the amount of work that you do. Okay. There's those exceptions again. Now, the compliance that I'm talking about really became massively enshrined in law, where the more complex numbers and amounts, where we used to have 2 households, 3 floors and 5 occupants, which I hear people still saying it's 2 households and 5 occupants is when mandatory licensing kicks in. If you need additional licensing, you are subject to all the same rules. The consequences of not doing it are immense. They're called civil penalties. They're £15,000 to £30,000, and the prosecution, if prosecuted, they're criminal. A civil penalty is an alternative to prosecution. So, if you don't know what you're doing, get help, not a fine. I see there are some people on here I know who've got some help from people along the way. Good that you're here and you're keeping up to date. You need to be a fit and proper person. So if you've been out doing bad things when you were younger and you've got criminal record, depending on what you have as a criminal record could determine whether you're a fit and proper person. And you have to be very, very sure on fire safety. Since Grenfell, things have really, really changed. But the most important thing is you've got to be prepared to battle. And when I say battle, not scream, not shout, bang your fists on the table. This is about understanding what the law is and understanding what's aspirational when a council is trying to give you conditions that you don't need to take. Once you take the conditions, they are taken. So at representation stage, when you put a license in, they'll send you a draft license. You'll have time to make representations of your case for or against any condition. That's when you need to do it. So who do you need a license? That depends, and HMOs often exist where they are missed. So let's do a quiz. Have you got your pens and papers ready? Okay, so looking at this slide, a 2-bedroom house or flat with 2 unrelated occupants. Write down on your piece of paper for number 1, is it an HMO? A 4-bedroom house with 2 brothers, 2 sisters and 1 cousin sharing. Is it an HMO? A 2-bedroom flat, 1 cohabiting couple and 1 unrelated occupant. Is it an HMO? I gave you the answer to that just a moment ago. It's a 3-bedroom house with 4 unrelated occupants. It's a 5-bedroom house. It's a couple with 2 kids and 2 people for their church living in 2 rooms. I gave you the answer to that a few moments ago, but there's also an extra piece of legislation there to share. Okay. It's a 5-bedroom house, 2 couples and 2 friends of the 2 couples. Now we have a converted block made up of 4 flats. The conversion is not meeting the building regulations of 1991, has 2 flats occupied by the owners and 2 privately rented. So it's 50% privately rented. For those of you who are a little bit more astute, that is, they're now getting into definitions under Section 257 of the Housing Act 2004. The Housing Act 2004, Section 254 is what I've been talking about the licensing so far. Okay, for those of you who like masses of detail. Looking through, converted block made up of 3 flats. The conversion doesn't meet the building regulations, and all 3 are rented privately with at least 1 occupant in each flat. Is it an HMO? And these types of properties I'm talking about, this is where you've seen an old big house being converted into flats. It's quite common in lots and lots of parts of London and other cities across the country. And the converted block made up of 3 flats, and the conversion doesn't meet the regulations, and it's 33% privately rented. And then one that's 50% privately rented. So write your answers down, no cheating. No cheating whatsoever, and I will come back to that in a minute. But the most important thing that I'm trying to make you aware of is you need to be aware of what you're doing. There are unlimited fines. There's a lot of unreasonable enforcement. Those room sizes are compulsory and non-negotiable now. And for councils, this is a new revenue stream. So what I'm saying to you here is do it or pay the price. So get educated. That's why you're here today, to get educated. There are no judges, and the council will enforce unless it goes to and once they do, you can only really go to the residential first tier property tribunal. If you think things are easy, a Newcastle landlord had to go to appeal because he had a block of flats and houses, and they needed a license. That was agreed by him and the council. The construction of the building, the council believed there were 4 dwellings and 4 licenses were needed, and the landlord said it was 1 building and only needed 1 license. So they were at a difference. So the important thing here is that when you apply for a license, the law is very, very clear. They either grant you a license or they refuse you a license. In this case, the council put it in a file and didn't apply the application and take it and process it. It sat in a file, and they then decided to prosecute him for not having a license. You couldn't make this up, could you? You couldn't make it up. They're prosecuting, but they were the people breaking the law. They hadn't granted the license, nor had they refused it. So if it gets complicated, get help. Now, the people who decide whether you get a license are the same people who enforce parking. And you know what they were like with that. You're also assumed guilty until proven innocence. So you need to prove your innocence. And they will fine you on everything that they can find wrong. And one of the councils, we were talking to them about 3 years ago, and they said licensing is a new source of revenue for us. And the key part there, as you see, is most councils make no reference to their websites. So, do you need a license? I referred to this earlier on. Under section 257, many converted blocks of flats may be classed as an HMO. So if you live in a purpose-built block of flats, there is no need for an HMO license because it wasn't converted. But if it is a converted block of flats, as many HMOs are, it might need an HMO license. And the criteria is, was building work taken out in the conversion, and how are more than 1/3 of the flats privately rented? So let's go back to our quiz. Right. So as you can see here, number 1, is it an HMO? No. Does it need a license? No. Number 2, no and no. Number 3, it's a 2-bedroom flat. There's 3 people, but it doesn't need a license unless additional licensing applies. Number 4, 4 unrelated people. Yes, it's an HMO, but unless additional licensing applies, no license required. A 5-bedroom house, so there's a couple and 2 kids, so that's 1 household, and 2 people from their church living in 2 rooms. Now, if they own the house, that's lodgers. If they're renting the house and they're from the church that they go to, those 2 would also be accepted. So that's very, very specialist, and you really do need to get confirmation from your local council that they understand. And even when you do that, go and get a professional to help you as well. 5-bedroom house, 2 couples, 2 friends, and 2 couples. Yes and yes, it needs a license. because there's two couples and there's two friends of the two couples. So that's 6 people in 5 bedrooms. The converted block of flats, it's more than 33% occupied as rented, so it needs a license. The next one again, but number 9, because it's up to a third, 2/3 are not privately rented, it doesn't need a license and it doesn't meet an HMO. So very, very complex that, and most councils do not understand. And my very good friend Richard and I are probably one of the few people amongst the community out there who really get that part really, really clear. I thank my parents for having a construction firm when I was younger. So there's a whole lot more to learn. Additional selective licensing, I mentioned the laws that they come into and under. So that's there on the screen. Part 1 for HMO and additional licensing. Selective licensing is part 3. So that's a very important slide. Okay. Yes, I'm going to be making available a recording of this, and so you'll get all the slides. Most importantly in London, it is getting very regulated, and as it says there, the same third boroughs that have selective licensing are not always the same third that have additional licensing. So now, this is in England. I operate in England. I don't understand the Scottish legislation or the Welsh legislation. They are different. And as a landlord in Wales, you do need to be a registered landlord. So 20% of councils have the wrong information on the website. So you need to make sure and reconfirm, always get things in writing. One environmental health officer will have a different interpretation to another. Many of the enforcement people are not fully environmental health trained. Some are only trained in HHSRS, so they'll do a survey. So they may not get everything correct on the first visit, and they may need to refer to management. Most authorities said they would impose additional, a third of them said they would impose additional or selective licensing in 2018, 2019. Many did, and as you'll have seen recently in the press, Liverpool has had their selective licensing scheme overturned. Okay, but there's more and more regulation. Landlords are being hassled to distraction. You need to understand what you're doing, and if you don't understand, get help. Now, this is the most important thing, is in the last 10 years, there have been 150 new laws and 400 pieces of regulation. There's 362 local housing authorities. That's 550 pieces of legislation in the last 10 years. That's 55 pieces of legislation or new laws every year on average, and there's only 52 weeks in the year. So that's more than one a week. Please tell me if you want to, what is the law that you learned last week? Okay. Right, so we're going to have a quick poll now. How many unrelated people do you need for an HMO to be formed? Is it 2, 3, or 5? Please mark it on the screen. No, not in the question box. Mark it on the poll on the screen. Right, lots of people doing 2 and then changing. I guess you're on mobile phones and your fingers aren't touching exactly. But you're all correcting those very, very quickly. So 84% of you got that right. Fantastic. 11% of you said it's 5. It's 3. The correct answer is 3. Yeah. For an HMO to be formed, it's 5 if it needs a license. Okay, so let's see what else you've done. Okay, let's get another poll. Okay. Oh, don't know what's going on there, but we don't want that happening, do we? The screen just changed. Sorry, let me just check you've got that. Right, so one more set of questions. So now this is a trick question. How many smoke alarms should you have in a 5-bedroom HMO? How many smoke alarms should you have in a 5-bedroom HMO? I haven't given you the answer to this. Is it one on each landing, one in each room, one in each room and on each landing, or I need more information to answer that? Come on, only 60% of you have voted. Everybody needs to partake here. This is about the safety of lives. Okay, so some of you said 57% have said one in each room and on each landing, and 38% have said I need more information to answer that. And 5% of you said one on each landing. It really depends on what is assessed in the fire risk assessment. You need to do a fire risk assessment and then apply lay cause fire safety to it and understand the smoke and carbon monoxide regulations too. So those who said 57%, that's if you are going to have maybe a grade A full panel system or grade D, but then that will determine whether the doors have intermittent strips and cold smoke seals or not. Okay, well, fantastic. Thank you for your participation. I am going to do one more poll at the end. So if you would stay the end, we are nearly all the way through. We're going to be going on to questions in just a moment. So some key things to remember. Ignorance is no defense. Seriously, this morning I've spoken with 2 people who are in denial of the situation they are in. If you receive civil penalties, if you get an enforcement notice, if you get an improvement notice from the council, although they're very helpful and very nice, treat it as being charged with a crime and get help. Don't go to them. You don't keep going back to the police station if you get charged with murder. You go and get a lawyer and you keep away from the police station. Now, some landlords are getting raided for not taking care. They're raiding them like the drug squads on the TV. People are getting raided who are persistent offenders. Some of you don't even know you're persistent offenders. Some of you aren't offenders at all. You're doing a really good job. But the civil penalties are real. The first civil penalty we dealt with was 25,000. The smallest one we've dealt with has been reduced to 2,000. Rent repayment orders are real. Licensing and planning have real power now. So you need to make sure that you don't breach planning, but that's not what this is about. But I will mention that as well. Planning, you will need planning permission if you have a house in multiple occupation that is 7 occupants or more, or is in an Article 4 direction for area. You need to check that as well. The housing regs are changing every day, really, really regularly. And the most important thing is you don't abdicate responsibility and say it's up to the letting agent. If your name is on the title, it's down to you. If you are leasing a property and renting it out and receiving the rent, it's down to you. If a property has a mortgage and it's the wrong mortgage product, the mortgage company may call in the mortgage, because when they apply for a license, they get informed. Okay, it's very, very important. And they will also check on the land registry that you are declaring things properly and whether it has a mortgage. So don't think you can get around this. Okay, so let me ask you, what is an Article 4 direction? In the poll, what is an Article 4 direction? Is it traffic assistance, a planning directive, an HMO license, or a fire alarm response? Okay, only 50% of you have voted. Can the rest of you vote now, please? Great, so 95% of you said it's a planning directive, and 5% said it's an HMO license. The 5% who put it's an HMO license, you will need to register for the recording and watch this again. And please, Article 4 is under planning and has got nothing to do with licensing. Let me repeat that. Article 4 is under planning and has got nothing to do with licensing. Okay, I'm lucky nobody said traffic assistance or a fire alarm response. So yes, it's to do with planning. Planning and licensing are like two different things. Imagine a diesel car and an electric car, or a diesel car and a petrol car, or a petrol car and an electric car. Although they are cars, they operate in different ways. Planning, building regulations, and environmental health are all different, but relating to the same thing. HMO licensing comes under environmental health. Environmental health. So some fun, some excitement. So key things: don't advocate responsibility. Your letting agent isn't you. They don't get done for most of the things, so you don't want to leave it so that they get you into trouble. The right approach: 1, know this stuff. 2, you need to do it. To know and not to do is not to know. I can't remember who said that phrase, but it is a true phrase. Yeah. I know that sometimes I need to take the rubbish out. But if I don't take the rubbish out, the rubbish doesn't get taken out, does it? So there's no point in knowing. Okay? So I need to know the consequences, civil penalties, rent repayment orders, all of those things. Go and find advice. Rent repayment orders are serious. I deal with a lot of them all the time. Most of the landlords that get the rent repayment orders are in denial that they've done anything wrong. It will destroy your business. It also could lead you to get civil penalties. The councils help the tenants get the rent repayment orders. Okay, and the most important thing is to be thorough, absolutely thorough. Now, can I ask everybody, have you learned something? If you've learned something, put LS in the question box. The letter L and the letter S for something. Learn something in the question box, and you learned something today. Wow, nearly all of you. Okay, I didn't need to do a poll. Good. Is this something that has been benefit to you? If it's been a benefit to you, put the letter B for Bravo or benefit. Okay. Would you like more of this? If you want more of this on a regular Friday, can we put the letter M? Okay. Okay, so we're going to be doing Friday Facts. I'm going to do these webinars every Friday, I think is going to be, subject to my wife's consent, that I can do these on Friday afternoons. And obviously, because I like to do these on Fridays, I like to work from home. Okay, so yeah, we're going to be doing more of this stuff, licensing, planning, all of those things that you need to run HMOs and to run your properties and to be proper as a landlord. So I'm going to go into questions now. I'm going to go into questions. So if you've got questions you'd like to ask about what I've said, I'm going to come to you. So write your question in the question box, and then I will then answer those for you. So write your questions, type them in the question box. Yeah. We've got about 6 or 7 minutes. I know I haven't told you everything. So if you're not asking questions, you're like the person who goes for a job, and at the end they say, oh, have you got any questions? And they say, oh no, you've explained it all very well. They know they haven't explained it all very well, and that's why you didn't get the job. So would you like to share with me some questions? Okay. So nobody's asking about rent repayment orders. Now the questions are coming. Can I access the Article 4 direction from our area? The easiest way to access if you have the Article 4 direction is to look in your Google Article 4 direction. So let's say you live in Hackney in London. You could put Article 4 London Borough of Hackney. Now it's best to put the borough in. Let's say you live in Dartford. You might put Article 4 direction London Borough of Dartford. If you live in let's think of a great town, Reading. So you might put Reading Borough Council Article 4 direction. So it's very, very, very important that you understand that. Now, Article 4, so I can explain, it's not only about HMOs. Article 4 is the removal of your permitted development rights under the housing, the Town and Country Planning Act. Now, this happened and was put into place by David Cameron's government, and that was about being able to do extensions on your house, etc. Article 4 removes that, but it could also be for conservation. So understand it's definitely about that. Okay, next question. Can you have a dining area in a large entrance hall? Well, that's it. I need some more information on that. But when you say a large entrance hall, if you have a property where you are, the entrance hall forms part of the escape route, you must have a clear escape route for all the occupants. So yes, you could, in theory, if you've got it, but how are you protecting the staircase? Is it open plan? Probably not the most ideal. Okay, i.e. you have to pass through it to get to an exit. And if there isn't a clear pathway, you need to make a clear protected exit for them, especially if it's an open dining area that connects to a kitchen. The kitchen has many sources of ignition. Okay, just to go over additional licensing. So yeah, additional licensing is where, so take your hands, two fingers on one hand up and 3 fingers on the other. If additional licensing applies, it normally kicks in at 2 households and 3 occupants. Some councils will say 4 occupants, but since October 2018, they've generally said with 3 because of the change. Yeah, so very, very important. Again, look on Google or look on your local council's website. Additional HMO licensing, London Borough of Barking and Dagenham, or London Borough of Hackney, or Westminster City Borough. Yeah. When can you operate as an HMO? From when you apply or when it's approved. The moment you make an application for an HMO license, it protects you from prosecution. And when I say protects you from prosecution, that's not all prosecution. It protects you from the prosecution that of making an application for a license, so operating without a license. Some of you are asking me how can I get in touch, etc. I put up a slide with my my contact details. Okay, so yes, so you can operate from the moment you make the application. So on the 1st of October 2018, many properties that were 2 stories had 5 occupants and 2 households needed a license where they hadn't needed it previously. So lots and lots of people made that, and some people still today haven't had their applications processed or have been given their license, but they're operating. I was talking to a gentleman this morning. We did 22 licenses for him. Those were selective licenses. That's not what we're covering today. He's had about 4 or 5 licenses through in the time since 1st of October. Right, thank you for that. A house converted into 2 one-bedroom flats. 1989, both flats are rented. One flat has 2 occupants and a couple, and the other has 1 occupant. Is it licensable? What a fantastic question. So it doesn't meet the 1991 regulations. It's got 2 flats, and more than a third are rented. One has a couple, and the other has 1 occupant. Now it doesn't say whether they're rented, so that scenario, if one is owner occupied or they're both owner occupied, it doesn't need a license. But if more than a third are rented, then it will need a license. Sounds like we need to have a conversation. If you could email me there at help@lldl.co.uk. Now, guys, if you is this interesting? If this in the question box, is this interesting for you? If it's interesting for you, would you like to have a newsletter on it? Then go to our website and go there. But that's the only thing I'll mention. If you want more information and you can't keep attending these things, we do a newsletter. Most companies do a newsletter. We have a newsletter. So you can do that at the link at the bottom under successes there. Okay? And do I have to inform anybody if I have 4 unrelated people living in the same house? And if yes, how? If it's what you've done there is you convert it into an HMO, it doesn't need a license because there's no additional licensing in that area, then you don't have to inform anyone, but you do need to comply with the Management of HMO Regulations 2006. And you also have to make sure that you've done the Housing Health and Safety Rating System survey, and you've done a fire risk assessment. Although you don't have to do a fire risk assessment, if there is a fire, you will be questioned on it. So do and assess it and look at lay cause. If you're not sure, get assistance from somebody who is competent. If you're asking the question about these things, most people are not competent. Yeah, we think we're competent and say, but do you really understand the fire safety order? If you don't, then you probably want to get somebody who does. If you know a fireman, or you can get in contact with a fireman, the fireman can do that for you. They know all of this stuff. Yeah. Staircases all have fire doors on. I'm not sure about why I understand that staircases have fire doors on them, but if you've got doors on and have fire doors, that protects the route. If you've got stairs, most stairs you'll need to put fireboard under them unless they're of a complete solid structure of concrete. Yeah, I'm not sure of the question. If you want to give me some more information, do councils have a timescale or requirement for granting or refusing HMO licenses? No, they just do it. They're both rented. So yes, that property where it's more than 50%, you would need a license. If your HMO is a flat that is exempt from mandatory licensing and no selective license or additional license applies to the area, what standards must be adhered to? Okay, I'm not sure I understand the question, but what I think you're asking is it a purpose-built flat? And if it's a purpose-built flat, and my good friend Jim Halliburton has done this recently, and you create HMOs in a purpose-built building, and you don't need licensing, you must follow the management regulations. Yeah, management of housing multiple occupation. And when does that kick in? As soon as 2 households and 3 occupants who are unrelated occupy the property. That doesn't matter if they occupy for a year or 6 months. It should do it. And an occupant generally means somebody who is on a tenancy agreement. It's their main place of home, work, and they stay there. They don't have somewhere else to go back to. Interesting. Yes, yes, there is a newsletter. Please go to landlordsdefence.co.uk successes. That's where our case studies are, and then at the bottom of the page there's an option to fill in if you want more information. Many people do ask. I can't see your link or your contact on the screen. Okay. Oh, that's because the poll. Sorry, the poll is still open, so I need to hide that. Right. Can you see it now? No, my screen isn't sharing. Okay. Great. Can you see it there? Now that link at the bottom there, you can do that. Let me put that in the chat because everybody's asking for more information. And that's the best way to get more information. I'm not here to sell you anything. I just see so many people getting in trouble, getting things wrong, and they don't know. And I really do want people to get this right. So if you look in the chat box, you should have a link there now if you want that. Sorry, I didn't realize when I said it that the screen I wasn't looking at that. Okay, what happens if you've had an unlicensed HMO because you didn't realize it needed license? Will I be penalized for the time it was unlicensed? It depends the circumstances under how you found out, and I wouldn't do it yourself because the most important thing is you don't want to self-convict. So get in touch. What you would do is you would put in for a temporary exemption notice, which would give you 90 days to either license or unmake it an HMO. Now this happens sometimes where you've got a house, it's an HMO, you've got 4 people in it, someone moves a boyfriend or a girlfriend in, or they take one of the living rooms and turn it into a bedroom unbeknownst to you because you haven't been in there for a month or so. So we had a classic one in February last year, went to look at a property on behalf of a landlord that was being managed by a letting agent. There was a family in there, so mother, father, daughter, and a family friend. And the family friend was there in order to get them the rent. And there were 4 of them. So it was an HMO, but no HMO regs were being followed. But on the inspection, we could see there was a 5th person in the house because they turned one of the living rooms into a bedroom. that house needed to be licensed. So a temporary exemption notice was put in. The works were done to put the to make the house compliant, and the people actually gave notice and moved out before the license application needed to go in. So the house is HMO compliant, and it works very, very well. Good afternoon. I'm interested in purchasing a 3-bed property with a separate lounge and dining room. So thinking that one of the reception rooms could be used to make it 4 rooms for sleeping. But in addition, it has a separate self-contained annex with 1-bed lounge, kitchen and shower room. It is all handled under one HMO license, or can the annex be handled separately? Right. So first of all, the annex, I don't know whether it has planning permission or whether it is a permitted development or whether it's all part of it. But yes, you would go to the council. You could make an application for all of it or some of it. It really is down to what you decide to do. Right. So you've got permitted development. You've got the planning in place. You say it's the annex. You say it's a separate self-contained annex. That would, I would need to see the drawings, because is it separate from the building or connected to the building? And I'd have to see how it's been built. I guess it's been built and fire regs have been followed as well. You say it's completely separate. Is it paying its own separate council tax? Yeah, so that's a case in point. You definitely need to get professional help. Now, one of the things that's very clear is I've gone 7 minutes over. So if you have got any questions and you do, and they haven't been answered today, please do feel free to send an email, and I'm happy to assist you if we can. But you know, we're here to help people, want to educate people. There's so much misinformation out there. Please do not take advice from someone who's telling you their opinion. Ask them, what have you done? Where did you learn your experience? And I ask you, you want to understand why we are able to share this with you, look at our successes page, and it just tells you some of the cases. You might recognize your own situation in there and realize you've got to do something. We talk to a lot of lawyers who specialize in property, and they ask us to help them on their cases because they deal with the law. What I deal with is the application of the law and the regulations from an operational basis, and understand how to protect people. That's what we do. I wish you luck. Thank you very much for joining us. Thank you for staying for the time. Thank you for staying to the end. It's been my absolute pleasure to share with you. And do keep in touch. If you like Facebook, my name's Des Taylor. Click on and connect with me. If you've got no friends and I'm the first friend for you, you need to send me a message and let me know, because I don't tend to just take friends from everywhere, people who've never been on Facebook before, because lots of stuff goes on there I worry about. Anyway, thank you so much, everybody. Great that you've joined us. Great that you spent some time. And if there's anything I can do, please do connect on Facebook and ask. And if I can help you, I'll help you. If I can't, I'll put you on to somebody else. And if you learn something, just rather than telling me thank you, just put learn something. If you learn something about this, wherever you heard about the webinar, please put a response there and give feedback so other people know. And if you want to get the recording, send them the registration link. They can get the recording from that registration link. You want to listen to it again, just go to the registration link again, and it will take you through the process to allow you to download the video of this webinar. My absolute pleasure. Take care. Have a great weekend. Thank you very much.